Hi, everyone. Welcome back. Welcome back. Everyone's doing okay? Good. Good afternoon. I like that. Very pleasant. Any questions? Anything on your mind? Anything lingering? Anything bothering you? No? Okay. So the past couple classes, we've been talking about the contract. You recall in the very first day of this topic, we looked at this long document with like 35 parts and discussing how do you actually engage in a sale of real estate. And I would discuss the most important part is that the title is merchantable, right? And what did a merchantable or marketable title mean? It means that when you buy it, you're not at risk of being sued, right? We did this one case, remember, with the house. That was one story, it was supposed to be 2 stories. Remember, it was too close to the sidewalk, right? And the fact is, because they had those violations, they could get sued, right? And the title was not marketable, okay? We also discussed various warranties, right, in the contract. So if you have a haunted house, perhaps, or if there's a latent defect, there are a number of things that must be disclosed. And if you fail to disclose those, you have remedies. Remember, the remedies are you can cancel the contract. In certain cases, you can retain the deposit or maybe get part of the deposit back. Right? Everyone with me so far? This was all discussing the contract, okay? Today, we are moving on to a new topic, and I want to make sure you don't confuse them. We are not talking about contracts. We're talking about deeds, okay? These are very easy to confuse, and I guarantee probably most of you are doing the read like, how is this any different than the house that was only one story? Why are these things different? The reason why is the previous topic concerned the sales contract, and this topic concerns deeds, okay? All right, everyone with me? Okay, so let's go off by a mini review. Okay, where did I finish off last? Omar, yes, my friend Omar. Yes, we went all the way around the room. I love going all the way around. This is actually a fairly small class. You guys are small. Usually I have 70 to 75 in property. This is barely 50, so you get more attention, which I like. You also get called on more, which you probably don't like, but it doesn't faze me. Omar, let's see mini review. Okay. What's the difference between a deed and a title? We discussed a couple weeks, maybe 2 weeks ago. Between a deed and a title. All right. You remember?
Yes. Deed is the actual physical paper to transfer title. Title is the ownership of the property.
Yeah, exactly right, okay? The title is the legal relationship, right? I own Blackacre. The deed is just the instrument, literally the piece of paper, right? The actual thing that you show that proves you have the title, okay? So that's the difference between a deed and a title. Okay, Omar, I'll go back to you. Try this one a little bit easier. What's the contract of sale?
Contract of sale is like the whole negotiations and
Yes.
back and forth between the seller and the buyer.
Yes.
Usually escrow agent.
Yeah. Okay, so exactly right. So the contract of sale is that long document you had at the beginning of our class last week or so, right? And this lists like 35 or 40 different terms, right? About the escrow and the closing date and lead paint, termites, right? Everything you can imagine. Okay. Usually, when two parties are negotiating, the contract of sale has all these detailed terms, like the price and everything else in there. Okay. But after you guys sign off on the contract of sale, there's another document. There's another document that you use to establish the legal title. Okay, and we just said, what's that document, Jimena? What's that document to establish a legal title? What's it called? Yes, the deed, right? So you start off with a contract, and it has like 35 different terms with everything you can imagine, and then you move on to a deed. And again, the deed is just the instrument explaining that you now have ownership or title to the land. And I want to show you from the book the sample deed. We'll get to the details of this in a minute, but you'll notice that this document is awfully short, right? It's like, what, 3 paragraphs? So instead of having a 35-page, this massive contract with everything you can imagine, the deed is pretty short. And it's short for a practical reason, right? This is what you actually record or register in the county office. The same way, remember, Mr. Robinson registered that affidavit. You actually bring this to the court. You don't bring the 35-page contract to the court, right? For one very good reason. Who wants to know? Why do you think you don't register a 35-page contract? Anyone want to take a guess? That's a good guess. Not the reason I'm thinking of. Anyone else want to think of a practical reason why? Nobody wants to store it? What's a really practical reason why you may not want to put all this up in the public record? Which part? Which term?
How much you pay?
How much you pay, bingo. People don't like advertising how much they pay for property because that gives you a lot of indication what your net worth is and your wealth is, right? So generally speaking, people don't like to advertise what they pay. Maybe they got ripped off, who knows? So what you usually record is the actual deed, which again is like a paragraph or 2 long. And we'll go through the details of this later. But I want to just make sure to drill into your head at the very outset of this class. This is not the contract. And the rules we discussed the last 3 classes on the contract are different than the rules for the deed. In fact, some of the cases, like we'll do the case from Connecticut, it's the exact opposite of the one-story house case, right? The rulings are totally different. So I'll make sure you guys are able to distinguish the two. Okay? Everyone with me so far? Okay. So we start off with the idea of a deed. And as we said, the deed is the instrument which discusses your relationship to the land. And the book explains that there are 3 general types of deeds, okay? Let's go, Michelle, just list them off. What are the 3 types of deeds? Yes, okay. No, just list them first. What's the one in the middle? Okay, good. Thank you. Generally speaking, there are 3 types of deeds. These, again, are the instruments that describe your relationship to the land. What separates one from the other to the other is what are called warranties, okay? Or you might know them as guarantees, okay? So has anyone ever purchased a new car, right? Usually when you buy a new car, they have what's often called the bumper-to-bumper, 60,000-mile warranty, meaning anything that goes wrong in that 60,000 miles, bumper to bumper, doesn't matter if it's mechanical, whatever, they'll fix it, right? And who here's bought a used car, right? Sometimes when you buy a used car, they'll give you what's called a limited powertrain warranty, where they'll just basically guarantee the mechanics, what's in the hood, but nothing nothing elsewhere in the car. Okay, that's kind of more of a limited warranty. And who here's bought a really cheap car, where it says as is? Okay, you guys know what I'm talking about, right? There's a big sticker on the window saying as is, which means you take it as it is. If something breaks the second you get off the lot, too bad. Okay, you can think of these 3 types in the exact same function. So the general warranty deed is like the bumper to bumper, right? It basically says we guarantee everything about the land, and if something's wrong with it, we'll cover it. Okay? The special warranty is kind of like a limited powertrain, just to use the example. What it means by that is we'll cover certain parts of the deed, certain parts of the car, but not all of it. The quick claim, the 3rd one, this is the quintessential as is, caveat emptor. In other words, you take it as you find it. If something goes wrong, we're not involved. Okay? Now, what do I mean if something goes wrong, right? When you have a car, what can go wrong? The engine can break, the wheels can fall off, the radio can stop working, right? There are very specific things that can go wrong. But with respect to property, we're worried about different things, right? So, Natasha, what possible problem when you buy a piece of land? What's the biggest conceivable problem you can have? Yes. The biggest conceivable problem that you can have when you buy a piece of land is that the person selling it to you doesn't own it. That someone else actually owns Blackacre, right? The worst thing in the world is you go and you buy Blackacre, and the next day some guy shows up and says, hey, wait a minute, I own Blackacre, you just got swindled, right? So what happens? You just paid all this money, and you don't own Blackacre, right? But we'll get to later. You may actually own Blackacre. For the most part, you don't. What a warranty does is a seller saying, listen, I am promising you that I own Blackacre, but I'm going to put my money where my mouth is. Because in the event that I don't own Blackacre and someone else with a superior title shows up, I will cover your loss, right? If someone shows up and says, no, I own Blackacre, I'll refund your money. This is what we call a warranty or a guarantee. Okay? And the most important one is what's called the covenant of season. Covenant of season or season. I've heard it pronounced both ways. I don't know. Who remembers, let's see, go way back, Peter. What's livery of season? Do you remember what that means? Go all the way back to property one. What's livery of season? How? What was it? What was like the weird thing you did? Do you remember? Yes. Everyone remember this, right? Where you take a clump of dirt, you put it in their hand, you take a twig, you twiggle them. Remember this, right? You should remember if you don't. It burns into your retina of law school, right? So season, like to seize or to take, right? It's related. That means you own the land. What's called the covenant of season or season means I promise that I'm conveying to you land that I own. Right? I am conveying land that I own. Okay? In other words, I lawfully own it. And if for whatever reason, maybe I'm not a crook, right? Maybe I'm mistaken. Right? Maybe I'm mistaken. Imagine if, like, you know, I obtained it and my deed was fraudulent. I didn't know. Right? For all I know, it's good, but it turns out not to be. I, with this covenant, with this warranty, promise you that if someone else owns it, I will reimburse you. Everyone with me so far? All right. Stephen, let me ask you a question. If I sell you Blackacre today, right, and it turns out that Peter actually owns it, at what point is there a conflict, right? At what point is your ownership of Blackacre in dispute?
Peter would come forward saying,
I'm glad you said that's wrong. What if Peter never shows up? And what if you go to Blackacre, right, and you own it, and the next day you go do a title search, and you discover, wait a minute, oh, wait, this guy Peter has got title to this. Peter's nowhere to be found. Is there something wrong with your title? What's wrong with it? Well, it's not that your title's fraudulent. He has a superior claim to you, right? He has a better claim. Could you sue me at the moment you find out?
under covenant of season.
Yeah. Yes, you can, right? You know what you said?
Yeah.
Yes, the answer is yes. The covenant of season means if you're not the owner of the land, right? If someone else has a superior claim to it, you can sue right away. Because that's a conflict that emerges immediately. The second you own the piece of land, there's this conflict. Everyone understand that? He doesn't need to wait for Peter to show up and say, hey, scram, you got the land. This is the Illinois mineral rights case we'll get to in a minute. That's what happens there. But with a covenant of season, presently you're able to sue the moment that you discover there's a cloud on your title. Yes, sir.
You have to vacate property or anything like that. Could you literally go, oh, somebody else has a superior title or a superior claim, so I'm going to sue you, get my money back, but the other guy's gone, so I'm just going to go ahead and sit here in the meantime.
It's a risk, right? So you can only do one or the other, right? If you sue for money, you have to leave, or you can stay. Maybe you say, I'll get up an adverse possession, right? I mean, you have a choice, but you can't do both. Yes, sir.
You just bring a quiet title claim and say that you actually own it. And he
Right. So that's actually what would happen. So I assume that it's clear that Peter owns it and not Stephen. But what if there's a dispute? So, sir, what's a quiet title action? We haven't used that word too much. What does that mean? To quiet title?
Quiet title is when
Like that?
yes. No, it's when the claim of the ownership is disputed.
Good.
Neither has necessarily a superior claim, or at least legally.
Exactly. That's exactly right. So what quiet title means is you go to court and say, hey, judge, I got a deed to Blackacre. Stephen's got a deed to Blackacre. I want you to decide who has the better claim. Right? And if the court finds that it's Stephen, right, then I'm going to get sued because I sold my bad deed because I have this guarantee on it. But the point that I want to convey for now is that this first one, it's called the covenant of season, is what's called a present warranty. What does it mean by present? You can sue immediately. That is, the moment I transfer the land to Stephen, there was a cloud on that title, and I can get sued right away. I don't need to wait for something else to happen in the future. There's a conflict on day number 1. Everyone get that point. These are important. We'll get to the language in a bit, but generally, a present warranty means you can sue right away. Everyone with me so far? Don't raise your hand. Okay. There are 2 other present warranties which are far less important. The first one, the covenant of season, this one's the biggie, right? This is the one that people sue over. The other 2 are not nearly as important. Ben, just can you list for me the other 2 present warranties? The present covenants.
The covenant of the right to convey and against encumbrances?
Yeah, those are it. Yeah, thank you. Yeah, it's in the reading. Yeah. So the second one's called the covenant. Students hate when I jump around. It's like the worst thing for law. It's like, where am I? Where am I? It's all in there, I promise. So the covenant to convey fee simple. And the third one's called the free from encumbrances. Don't get too worked up against the last 2 because they're basically the same as the first. There's a subtle enough difference, but not one that actually matters for this class. All of these basically mean that the person who sold it to you was able to convey fee simple, that they were able to convey to you the land that they described. Okay. There's actually a bit in your reading, which I hope you picked up on, that why is it that property professors often use 2 or 3 words to describe the exact same thing? The reason why is experience, right? If some court 400 years ago said if you have the word season in there, it's okay. And then some court 300 years ago said, oh no, you need this covenant to convey fee simple. And some court 200 years ago said, oh, you need this covenant to be free from encumbrances. As a lawyer, you want to be responsible. So you include all 3 just to cover your bases. And because of this practice of covering bases from 500 years ago, right, we have always 3 or 4 ways of saying the same damn thing. So all these present warranties, what are called present covenants, the words are synonymous, right, in this context, mean that I am conveying to you land, and if there's some sort of doubt on the title, you can sue immediately. Any questions on this? Yes, ma'am.
So I have some confusion about this warranty with some definition in the contract law.
Mhm.
Because I remember in contract law there is the express warranty and the implied warranty, and according to the implied warranty, the owner should make the title legal or something. Is it the same thing?
So I want you to resist trying to analogize to the contract doctrine because it's very different.
Very different.
Yeah.
Oh.
Contract law doesn't govern real property. So very often you'll have the same term in this class and in contract, they mean very different things. So just try and limit the definition we use here, okay?
Okay.
Your instincts are exactly correct. You want to say, oh, I learned this word in contracts, but they're different bodies of law. They often have different meanings. Okay? Yep, you're welcome. My pleasure. So the 3, what are called the present warranties or present covenants, all discuss at the moment of sale. At the moment of sale, do you own this, right? Do you actually own it? Okay. But the flip side to this is these warranties can only be broken at the time of sale. Okay. Why can these be broken only at the time of sale? Caitlin, want to take a shot at it? Why can the idea of whether you own it or not, why is it only relevant at the time of sale? Let's use the example before, right? I sell Blackacre to Steven. Turns out Peter actually owned it at the same time. Does it matter what happens afterwards? No, after I sell it to Steven, yeah, and it turns out that Peter owned it previously. Does it matter if anything else happens afterwards?
No,
Why not? That's right, why not?
because the title costs Stephen
When can I sue under this warranty?
immediately.
Yeah, so does it matter if the circumstances change later?
No.
Exactly. Once you make the transaction, once I sold to Steven, this covenant was breached, and he can sue immediately. He gets his money right away. He can't then go and double dip if something happens later, right? The idea of the reason I call it the present, meaning like now, is you sue on them at the time of the sale, right? If at the time of the sale you discover that there's someone with a superior claim, this covenant was breached, and then you can sue on it and get damages. Okay? Everyone get that? Alex, so does that mean you have to sue on the day of the sale? So if you find out on Monday, you have to run to court and sue on Monday. Is that what that means? So when do you actually have to sue? Generally speaking, how do we know in court when we have to sue by? What's that thing called? Oh, you know this. How long do you have to sue in court? Someone beats you up and commits a tort. How much time do you have until you can no longer sue in court? Thank you. Statute of limitations, right? So there's a statute of limitations. So I'll say at time of sale plus SOL. Everyone know what SOL means? Out of luck, right? Statute of limitations. So you basically have the time of the sale plus the statute of limitations, which 10 years, whatever it is. So the rub over the present warranties is, although you can sue on a wide range of claims, you have to do it within the limitation period. This is the problem with the mineral case we'll do later. They didn't sue quickly enough. So if at the time that Peter discovers Blackacre has another owner, or even within 5 or 6 or 7 or 8 years later he discovered it, he can still sue on the original covenant from the deed. I understand. Any questions? Sure, you got this. All right, so let's take a look at the actual contract. It's on page 616 in your book. I have it up here as well. Okay, so this is the deed, right? And again, it's a very short, brief document. There's I, blah, blah, grant to so-and-so for the price of whatever. This piece of property, and then you describe it. We don't care about that. What we care is this paragraph. And for your utmost convenience, the clauses are numbered. This makes your life easier. So for now, we'll focus on the first 3. We'll get to the latter 3 in a minute. But let's focus on the first 3. So it says the grantor. So review. Norma, who's the grantor in a transaction? Louder? The person who's the seller, right? Yeah, the seller, the grantor, person who's selling. And who's the grantee, Norma? Receiver, good, buyer, exactly. So the grantor for himself, his heirs, and assigns. Norma, what do you think that language means? We haven't really talked much about that, but what do you think that means, the grantor for himself and his heirs and assigns? What do you think that means?
Well, that you're
No, read the full sentence. The grantor for himself and his heirs and signs covenants. What does covenants mean? Yeah, it's a promise. A covenant's a promise, right? So, Norma, who is making the promise here? And who else? No. Yeah, so see what's going on here. The seller is saying, not only am I making this promise, but my heirs are making this promise. The people I assigned this deed to make this promise. Basically, in other words, this goes on beyond my death. This goes on beyond my lifespan. So if I own it and then I die and my son inherits it, my son will now be bound by the same contract. Why is this important? Because the general warranty deed can go on for 100 years. If you sell a piece of property to a family, it can be in the same family for a century. Right? So this is important to say everyone promises. Okay? Dominique, read the first one, right? Number one.
Covenants that the grantor lawfully sees in fee simple defenses.
And keep reading it. Read 2.
That he has a good right to convey the fee simple.
And just go to 3 while we're at it.
That the premises are free from all covenants.
Very good. Okay. These are the 3 present warranties that I put up on the board a second ago. Okay? That you're lawfully seized, right? That's the covenant of Sison. That he has a good right to convey, that's the right to convey. And number 3, the covenant against encumbrances. That means that there's no mortgages or liens or anything that basically damages your title. All 3 of these basically mean the same thing. The property you're selling is something that you own, and there are no superior claims hovering somewhere else that can come back to haunt you. Okay? So Dominic, I want you to pay very close attention, right? Let's remember grammar. Remember way back when in grammar? Are the verbs in this sentence in the present tense or in the future tense?
Present.
Good, right? See what it says. The grantor is lawful. He's like, today is seized. That he has a good, present, right? That the premises are free, present. So if you're ever looking at a contract and you're not sure if a term is a present covenant or a future covenant, which we'll do in a minute, the cheat, right? The way you can cheat is by looking at the verbs. See, they're all present tense. Now, Josh, go ahead and just read number 4, please.
The grantor and his heirs can assign forever one and agrees with her heirs and assigns against every person lawfully claiming premises for any partner.
Okay, good. Stop right there. Everyone see the difference, right? In the first 1, 2, 3, it's all is present, right? But number 4 says the grantee and his heirs will forever. Will is in the future. And not just to the grantee, but the grantee and her heirs. Okay? If you haven't sensed by now, you should be building up to it. Numbers 4, 5, and 6 are what are called the future covenants. Okay? Number 4, 5, and 6 are the future covenants. So the way you cheat, and this is a very easy way, is the present covenants are in the present tense. And the future covenants are in the future tense. And if you don't remember grammar, even easier, the verb will is going to be there. I will covenant. I will forever. This, yada, 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 right? Everyone with me? All right, so let's go through 4, 5, and 6, the future covenants. Sam, just read for me from the book, please. Numbers 4, 5, and 6. What are the future covenants that we're dealing with? No. I'm sorry. What are they called? It's in your book later. Yeah, what are they called? Okay, so number 4 is a covenant of general warranty. Thank you. What's number 5? Thank you. Okay, thank you. We have the covenant of general warranty. 5, the covenant of quiet enjoyment. And 6, the covenant of future assurances. So, Sam, let me ask you this question. we said before that with the present warranties, these are problems that arise at the time of the sale. When do you think these problems arise? Exactly right. Okay? These are problems that arise in the future. Okay? Now, Mike, let me ask you a difficult question, right? What if any problems arise the minute you buy the property? Which would you rather sue on? A present warranty or a future warranty? Right? Say the day you move in, you discover that, you know, Peter actually owns the land. Would you want to sue on a present warranty or a future warranty? Why? You are in the present. It's like a Back to the Future lesson, right? If, and this is a common error, so I'm glad you said it. It was a tough question, right? If the problem exists at the time you sign the paperwork, you sue on the present warranty. Okay? The future warranty is indeed after you have the transaction, something else arises. Okay? I'm glad you said that. It was somewhat of a trick question, but it was good. The most important one is number 4, this covenant of general warranty. Ryan, how does the book define that one, this covenant of general warranty?
It basically says that the grantor will defend against lawful claims.
Yes.
Basically saying that if someone's not going to have a lawful claim, they can remove the grantee, that they'll pay for it. But if the grantee wins the case and still has title, then it's empty.
Perfect. And you said something very important, right? So the example I gave before, right? I said Peter was the owner, but he was vacant, right? We had no idea where he was. Ryan, could I still sue the seller for money, even if Peter never shows up?
No.
Under the present warranty?
Oh, under the present warranty?
Yes. So the key difference is under the present warranty, no one has to bother you, right? No one has to show up and assert their legal claim. But Ryan, you already said a second ago, under the future warranty, can you just sue because someone has a superior claim?
No.
What has to happen?
They have to come and find
They have to come and bother you, right? So effectively, there has to be, and I like the word you use, a lawful claim. A claim has to be made against you. So to go back to the question I asked Mike, which would you rather sue under? You'd rather sue under the present because it doesn't require anyone to bother you. On this one, and the part that might seem counterintuitive, you have to wait to get sued, right? You have to wait for someone to come to you and sue you and say, this is my land. Because until someone sues you, your title is effectively unmolested, right? Your title has not been bothered. I will say that the biggest difference between the present warranties and the future warranties is that with the future warranties, you got to get sued first. With the present warranties, you can be proactive and sue the original seller, saying, hey, you ripped me off, give me money. Everyone get that far? Okay. This is the easiest mistake people make in the exam. It happens every year without fail. About 5 or 6 of you will, I promise. So make sure you get this right. With the future covenants, you basically have to wait to get sued. And I can't say it any more clearly than that. You have to wait for a lawful claim to be made against you. And then and only then will the original seller come in and cover your fees and pay for your losses. Okay. Yes, ma'am.
Would you relate the general warranties like indemnity clause?
Oh, good. Yeah, yes. That's actually a very good model, right? An indemnity clause. Well, you tell me what's an indemnity clause? Indemnity clause.
You like clause the contract stuff and the other person sued if they not liable.
If they're sued, though, right?
Yeah.
Only if they're sued. Exactly right. What's key here is you got to get sued first. Someone has to file a quiet title act and say, wait a minute, there's a superior claim to the land. Everyone with me so far? Okay. So number 5 and 6 aren't that much different. Quiet enjoyment is a term. It has nothing to do with silence. He was like, what if I have a really noisy neighbor? Can I sue under the covenant of quiet enjoyment? No, no, no. That simply means that basically no one with superior title will bother you. No one with a superior title will bother you. What does that mean? Well, same thing as number 4. For your purposes, 4 and 5 are more or less the same thing. There's subtle differences, but for this class, they don't really matter. The covenant of further assurances basically says that the grantor will execute documents. So, you know, maybe if you need to have some sort of inspection done and the original seller needs to sign something, they promise they won't be jerks and they will reasonably sign whatever documents. That one, I can't imagine how that would even matter for you, but it's usually in there. Everyone with me so far? So let's go back to the contract on page 616. Okay, I said contract, I was wrong, the deed. So we have, again, the first 3 are all the present tense that you're lawfully seized. That's called a present covenant. The latter 3, they're all staged in the future.
I had a question. It had to go with number 4.
Yes, sir.
On warranty. The case where they had the oil underneath the ground and they had sold it and they're supposed to reimburse for losses. Is that just what they paid for the property, or now that they found oil on the property and they didn't? If you sell land, you have a general warranty, and you say, if someone comes and has better tile, I'll reimburse you for it.
Uh-huh.
And in the meantime, they find oil, do they reimburse?
Okay, all right, so the question is this, right? How does it work when the sales price without oil becomes much higher when they find this oil underneath? Is that basically your question?
Yes.
Okay, so generally speaking, in Texas and in all states, when you buy a piece of land, you own the land down to here, right? That's the Ecoelum doctrine, right? You own everything above and everything below. If the contract doesn't specify surface rights only, then it suggests and implies that it's also covering everything below. So measure of damages, though, I think would have to actually be based on, you know, what the actual loss is, right? And I gotta look up this. I gotta look up. I'm pretty sure the loss is based on what you paid for it, because if you think about it, if you sell a piece of property for say $100,000 and they discover a $15 million oil deposit underneath your house, it's not reasonable for the seller to assume that sort of liability. You understand?
Yeah.
I'm pretty sure I'm right, but I'm not 100%, but I'm pretty sure you're not going to get that. We'll do a case similar to this where that didn't really come up, but I'm pretty sure what the seller will be on the hook for is what you paid for it, because there will be some sort of unjust enrichment to a significant degree if you make the seller pay for $50 million oil reserve when he got $100,000. Right? It wouldn't really make sense. I'm pretty sure that's right, but I'm not 100% sure. Okay? So you have the present covenants and you have the future covenants, right? Cameron, so let me ask you this question, right? What happens if you've been living on a piece of land for, say, 30 years, and then all of a sudden Peter shows up and says, hey, wait a minute, that's my black acre. Well, let's say he didn't know about it. I just said that, right? Let's say he didn't know about it. Is it too late to sue on your warranty?
Part of me thinks there would be a limitation of some sort, so yes.
Well, read number 4 very, very carefully.
Oh, that's right. It applies for like 100 years or so.
Oh, no, it's longer than 100 years. Read number, please read number 4 for me very carefully.
That the grantor and his heirs and his sons will forever.
Forever?
Warrant.
Forever. How long is forever?
Forever.
Forever and ever, infinity beyond, right? Forever means forever. So the aspect of the future warranty is it indeed goes on forever. So if in 30, 40, 50, 60, 70, 100 years, someone shows up and says, wait a minute, I have a superior claim, so long as you're still holding this general warranty deed, you can then sue. The grantor may be dead, but the grantor's heirs, right? Remember this part up here, a minute ago, the grantor and his heirs. So you track down those heirs and you sue them because you're holding that general warranty deed. And it's not just the grantee, right? It promises, where is it? The grantee and her heirs, right? So it's not just the grantor and the grantee. It's the grantor's heirs and the grantee's heirs. Everyone see that point? Look who's getting promised here. The grantor and his heirs are promising the grantee and her heirs. In other words, the seller is promising the buyer. And it goes on forever. So the general warranty deed really goes on and on and on forever. Yes, sir.
Again, I'm not sure if this isn't as wild as the oil one, but if you buy land, let's say in 1900, and then in 1980 someone comes and says, hey, I actually have title, but of course land has gone up, do they still go back to the original contract price, or does it go up? Is that what they would have sold it, like market value?
I have to again look it up, but I think it's based on what the seller and his heir sold it for. Because it would be significant unjust enrichment if the property value quintupled, right? But I'm not positive on that. I'll look at that. Now, Cameron, let me ask you the follow-up, right? Let's say that in 1980, Peter comes up and says, hey, scram. And you're like, screw it, I'm not doing anything, right? And then finally, year 2015, you decide to sue. Can you do that?
Yes, because, no, maybe.
What do you think?
Well, you know, the guy came up and said, you know, this is mine, blah, 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 and then you didn't do anything. So
What do you think the law would do for a person like that?
I think the law would probably say, you know, you really should have taken action immediately.
So he's right. The statute of limitations starts ticking at the time of the breach, right? When someone disturbs your possession, or someone disturbs your quiet enjoyment, or someone tries to throw you off the land, you start the 10-year clock. Siri's beeping somewhere, right? You start the 10-year clock. So even though it goes on forever, once the claim happens, once there's some sort of breach of quiet enjoyment, you then have whatever the statute is, 10 years. Questions? Yes, sir.
I guess are these enforced like on a contract law basis, or do they allow punitive damages, or how do they?
Well, so the contract we did, the case we did last week, remember the one from where they awarded punitive damages? Those are very rare. Property law doesn't usually have punitive damages. Usually it's compensatory only. So I don't know if there's a provision to get punitive damages on a deed. I can't imagine why, but that strikes me as an odd choice.
I was just thinking, like, if your great 47 times grandfather was a real a-hole, messed somebody up.
There's a term of art, by the way, the a-hole, right?
Absolutely. And, you know, all of a sudden here we are 2015 and you're having to deal with things that he created.
Yeah, I think it'll be a tough stretch to impose punitive damages on a fourth heir, right? And so any questions on this, right? Can't see. Yes, ma'am.
The statute of limitations you said that starts running when someone.
When your quiet enjoyment is disturbed.
So what if you find out that something's wrong and she's not to do anything about it? Do you have to wait till someone can bother you?
Well, okay, so say you find out and you do nothing, and then you finally get evicted, right? If it's too late, you can't sue on the original deed. You can't get damages. In other words, if Peter says, "Hey, scram Josh," and I don't do anything for 10 years, and I burn my statute of limitations, and then Peter finally moves to evict me, right? I can't sue on the deed to the original grantor because I waited too long. All right?
Earlier you had said that they had to sue or try and get adverse possession, and you could not do both with the present warranties.
I think what I said is if there's a violation of the present warranty, you can either just stay there and wait and hope Peter never actually bothers you, and maybe you can try for adverse possession, or you can sue, in which case I think at that point you'd have to vacate. I can't imagine that you can simultaneously sue on the warranty and continue living there. That seems a little odd.
Then I guess with my
Because in other words, Ryan, let me ask you a question this way, right? The seller will only pay up if indeed Peter's a true owner, right? So in other words, you have to go to court and say who owns Blackacre. If it is indeed Peter, then the seller pays up. It's not just enough to think, hey, I found this record, give me my money, right? You actually have to have a court proceeding to, so the seller knows he actually has to pay up. Questions? Yes, eeny, meeny, miny, mo. Yeah.
You have the seller pay the original owner off so that Peter gets to keep the land.
Could you have the seller pay the original owner off to
The
keep?
seller that, like you're gonna.
I mean, I suppose you could then try and buy it from Peter. I mean, that always works. Whatever money the seller would give you, you could use it to buy Peter off. Yeah.
So the statute of limitations, and it wouldn't start until the actual buyer of that property.
Shows up. Yeah. Not yeah. That he shows up and disturbs your quiet enjoyment.
Well, let's say somebody else owns it. Like we're talking about average possessions, owns it, and this person's been living there for 30 years. The clock would start ticking until the actual
Claim is made.
claim is made.
Yeah.
So essentially, all these warranties can be broken if somebody else really owns it.
The future warranties, yes. Be precise. The future warranties can be broken if someone else shows up and makes a claim. The present warranties are violated only at the time of the sale. Okay. Good questions. Good questions so far. All right. I put up on the class page a sample contract. I think it's from, was it Brazoria County? Somewhere in Texas. I can't remember where it was. But you'll find that there is, oh, where is it? Yeah, here it is. You'll find that there's very similar language. The one in your book is a little bit easier to read because they're numbered clauses. But this language says, his heirs and assigns forever. Here do I bind myself, blah, 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 to warrant, to defend all the premises. It's basically the same gibberish language to say, this is a, oh, let me ask you, Taylor, reading this paragraph, right? This paragraph right here, would you call that a present covenant or a future covenant? Why do you say that?
They're talking about one
Yeah, yeah. If the word forever is in there, that's a pretty good clue. We're talking about a future covenant. Yeah, exactly right. Yeah, I mean, this one, the language in your book is a lot cleaner, but this is one you may actually confront one day. Again, all these words are repetitive and duplicative. Why are they there? Because at some point, some judge said you need this word. Another judge said you need this word. And a third judge said you need this word. So lawyers, we're very, very scared people. We don't like screwing up. We say better safe than sorry. Throw the entire, the entire dictionary there. Every word 18 times repeated. Okay. Any questions? Yes, yes, ma'am.
I want to ask, the deed of warranty is the certificate of ownership. Am I right? If I have the certificate, I own the house.
Yes.
Oh, okay.
Yeah, yeah. And better than certificate, instrument is the word we use. It's like a document to show that you own the land. And on this document are these warranties or covenants, which are like promises saying, here I own the land, and if for whatever reason something happens, I can go back and sue on these 6 different items. Other questions? Okay. I don't care if you know the names for each of the 6 of these. As I said, really the first and the fourth are the only ones that actually matter. The other ones are largely duplicate. But what you do need to know is the difference between a present and a future covenant, because the big difference is when you can sue on them. And as we'll see in the cases today, that's where people screw up. They sue on the wrong covenant, or they try and sue on a future covenant when it's really a present covenant they're challenging. Everyone get that? Okay. So let's go to the first case, Brown versus Lober from Illinois. Figures you have the only mineral rights case in the entire semester from Illinois. Figures, right? Paul, what were the facts in the Lober case? What were the original transactions that gave rise to this case?
The original transaction was that it contained deed for some plans. But I guess the caveat was that the original owner reserved 2 days of rights to the mineral rights.
Good.
So,
Yeah. So when you sell a piece of land, you don't have to sell the surface and the subsurface rights together. You can sell, I'll give you the surface rights, but I'm going to reserve for myself 2/3 of the subsurface rights. Because in the event they ever find coal or oil or whatever other minerals they find underneath it, you know, the original owner gets a cut of it. Transaction, you're right, Paul, was 80 acres, but there was a reservation of the mineral rights. Then what happened? By the way, that let's just do the chronology because the dates actually will matter. So in was it 19? Was it 47? The sale to the boss with 2/3 reserved. Okay, Paul, what was the next transaction?
10 years later, they had the lands of Brown and White by Bill.
Perfect. Okay, so the boss sells to the Browns, but with a general warranty deed. By the way, GWD is general warranty deed. In case you don't know, but general warranty deed. Okay. Was there any indication, Paul, that the mineral interests were reserved?
No, not. I guess not the party.
Okay, very good. Okay, so Maricela, when you sell land with a general warranty deed, what is the most important covenant that comes along with that? And we discussed it just a minute ago. What's the most important one? What's it called? Yeah, yeah. And what's the covenant of season say? Good. So if this deed says, I'm selling you the entire lot, top and bottom, did the boss actually have season or ownership of everything top and bottom? Okay, very good. So Maricela, at the second this general warranty deed was signed, was it breached? Yes, exactly, right. So the second it's signed, right, there's a breach of the present covenant of season for the reason Maricela said. The seller did not have the land that he purported to convey. Everyone get me? Get with me so far, right? The second he signed it, there was a violation of the present covenant. Good. If they want to be honest, yes. Right? So, Jimena, I'll ask you this question, right? Why do you think the boss didn't mention anything about the subsurface rights? They didn't know. So it was an honest mistake, right? This was not a fraud transaction. It was an honest mistake. First person was maybe a fraudster, right? But boss was not making he was not trying to defraud anyone. But when you give a general warranty deed, it doesn't matter if the mistake is honest. That's the key, right? When you give the general warranty deed, you're giving your promise saying, listen, I don't know for certain if I own it, but I think I do, so I'm going to put my money where my mouth is. And this was in the reading. Usually general warranty deeds are much more expensive, right? If I want to go on the cheap, I'll just get a quick claim deed, which has no assurances. The general warranty deed has a promise and usually twice the value. They're worth a lot more, okay? Now, the Browns could have sued immediately, right? But they didn't, right? Why didn't they sue immediately, Jessica? Why do you think the Browns did not go the day of the court and sue right away? I'm sorry, I can't hear you louder, please. No, you're thinking too hard. Why did the Browns not sue right away? Maricela said the covenant of season was violated, right? It was breached. Why didn't they sue right away? Very easy answer. Think about it. What would have to happen in order for them to sue? What would they have to know? What does it mean for the covenant of season to be breached? What does that mean? Maricela said it a second ago. What does that mean for the covenant of season to be breached? Haley, what does it mean for the covenant season to be breached? Okay. They don't have what they purport to convey. Why did the Browns not sue right away? They didn't know. And why didn't they know? But there was a way for them to know. And this is the rub. Property records are public. They should have performed what's called a title search. My friends who have actually acquired property know what a title search is, right? What's a title search again?
Title company, they'll search the issue of title and come up with any kind of.
So had the Browns gone to a title company and they paid for a title search, which aren't that expensive, would they have uncovered that someone owns the mineral rights? Right. The boss never did a title search. The Browns never did a title search. As a result, neither were aware that someone had a reserved interest to the mineral rights. Okay? So instead of suing right away, they waited some time. Okay? So go back. Jessica, what happened then in 1974? Who did they try and sell it to? Good. So, okay, so here's what happened, right? Brown wanted to sell their mineral rights to the coal company, right? Jessica, do you think the coal company does a title search? You bet you do, right? That's their business. Their business is to make sure that when they're extracting minerals, they have a lawful title. So the coal company does a title search, and they discover, wait a minute, buddy, you only own 1/3 of your rights. You don't own the entire thing. The 2/3 was reserved to the boss many years ago. So they offer to pay them only for 1/3. Okay, good. Urvashi, what happens next? What's the lawsuit? And what year was the lawsuit filed? I don't care about the year. What was the nature of the? What did they sue for? I'll give you the year in a second.
They sued for the breach of covenant of quiet enjoyment.
Okay, very good. And it was actually 1975. Okay, they sued for the breach of the covenant of quiet enjoyment. Urvashi, what type of covenant is that? Is a present covenant or a future covenant?
No, yeah, future covenant.
You're right. It's a future covenant. Okay, Urvashi, how do we define a future covenant, right? At what point are you allowed to sue on a future covenant? At what point? Sorry? Not when you find out.
In the future, whenever it happens.
What happens?
When the breach happens.
Okay, good. At what point is the quiet enjoyment covenant breached?
When they found out.
No.
When the possession was fulfilled.
By whom?
By the original.
Yes, exactly right. The only way for quiet enjoyment to be disturbed would be by the original owner, the guy who sold to Bost. Everyone see that this is the important point of the case. The point at which their enjoyment is disturbed is if the original guy who owned the 2/3 interest shows up. Urvashi, is it enough that they learned that they got screwed and ripped off? Is that enough to find a breach of the covenant?
No,
It's not enough. The key aspect of the future covenant of quiet enjoyment is that the original owner who owned the 2/3 interest has to show up. Everyone understand that? Okay. The original owner never showed up, therefore, too bad, they can't sue. Rachel, let me ask you this question. Which covenant should they have sued under? Ideally, in a perfect world, which covenant should they have sued under? Marcella said it a minute ago. Yes, they should have sued under the covenant of season. Is that a present covenant or a future covenant? Good, present. Why did they not sue under the present covenant? Exactly, the statute ran. They bought the land in 1947 or 1956. They didn't sue till 1975, 20 years elapsed. So see what happened here, right? They tried to get creative. They said, uh-oh, we burned our statute of limitation for the present covenant. Let's try to squeeze this in to the future covenant, which means we can sue at a much later date, right? Because they didn't want to sue the original guy, right? They want to sue the Bosts. Okay? Aaron, did the court let them do that? Did the court let them try to squeeze their expired claim into this future covenant?
So they should have had a title.
Yeah. The court in Illinois said no go, right? You cannot transform this claim, which was burned by the statute of limitations, using the future warranty. You should have done a title search. Had you done a title search, you have discovered within 10 years that the season was violated, and you get sued right away. Yes, ma'am. You tell me, when does the statute of limitations in a present covenant start running? No, on a present covenant. No. When does, here, I wrote it. When does the statute of limitations run? See, these notes used for something. Yes, ma'am. At the time of the sale in 56, whatever it was, that's when the clock starts ticking. You have 10 years from the moment that you sell the land, or buy the land in this case. So everyone understand this. Until you're actually molested, right? Until you're actually disturbed, until your ownership is bothered, until someone tries to sue you, a violation of a future covenant does not happen. It's not enough that it could happen. It's not enough that someone can come by and sue you. It has to actually happen first. Yes, from the back.
Are they actually required the buyer of the grounds to do that kind of search?
So the answer is no. You're not required to do a title search, although if you don't, you're very stupid, right? They're not expensive and they can save you a lot of headaches. Now, in the olden days, the reason why general warranties were valuable is title searches weren't possible. So we have computers, we have very established records. 200 years ago, you didn't have very good records. So a general warranty was your way of buying insurance. They're saying, okay, in the event someone shows up, I can then sue on it. But you can only sue when someone shows up and tries to kick you off. You can't sue out of speculation. All right? This is proven amply in the next case, the Connecticut case. Yes, sir.
Let's see. While I was looking for the encumbrances, is that possible in this situation? I was just kind of looking up the definition. It's kind of talking about like a restraint or a drawback.
It's basically something that clouds your title. In this case, what? He owned the surface, but he didn't own 1/3 of the subsurface, right? Could he still live on it? Sure, but there's something that weakened his title, right? However minute it is, it's something that weakens your title.
Well, yeah, I'm saying under this, we're talking about suing for the covenant of season.
Yes.
But they couldn't because of statute of limitations.
Right.
I'm saying, could they do it? Could they have tried for the free from encumbrance?
But that only kicks in when someone bothers them, right? It's only when someone comes in and seeks to enforce their rights. That's the key aspect of the future covenant. Someone has to sue you. Until you get sued or someone tries to evict you, you still own it.
I'm not talking about future. I'm talking about
Present. Oh, if it was a present covenant, sure, yeah. The first three, the season, the encumbrances, they're all the same thing. It's basically the same thing repeated 3 different times. As I said, don't get caught up on the distinctions, right? It's the same concept repeated 3 different ways. But yes, you're right. Yes, sir.
I'll jump off a little bit and ask a rights question a little bit.
What rights question?
Like the ownership of the minerals. Like there are oil companies that come in and lease the mineral rights, but the owner is somebody that has no clue where the land is or anything. They just know that they get a check every month. If the oil company does something to that land, to the surface, which they don't own, can the surface person sue the remote owner?
Well, generally speaking, if you own the surface rights, for them to drill, you need to at least give them some right to trespass on a specific portion, right? If they exceed the scope of that license,
Or
then
if they spill salt water all over everything around.
you're asking a specific question that you're aware of? It's hypothetical, or is this a real question?
Well, I mean, it's happened many times. So it's general. It's not about a specific event.
Right. I mean, if they go beyond their license of trespassing.
Yes, and then, but it's so hard to get anything out of the oil company.
Yeah.
And you sue the actual owner that is leasing Like, because they're the oil company.
There's usually indemnity arrangements where you can sue one or the other. It would really depend. You okay? I'll stack in the back, right? Other question?
Why couldn't they sue under the general warranty? I guess I'm confused.
Which one? The future?
Yes.
So I let me say this point very clearly. You can only file a suit when you're sued. You can only rely on one of the future covenants when you get sued. Had anyone bothered? Had anyone sued them about the oil rights or the mineral rights?
No.
Until that happens, there's no lawsuit.
I was confused. I thought it was.
Yeah. Let's make this very, I can't write any more clear it. You can file when you are sued. Clear? Only when you're sued. Right? So the Illinois court said until a future warranty is actually breached, someone tries to kick you off the land, you cannot sue on the covenant. And it's a little disturbing. It's kind of a wait and see, right? You have to sit around waiting. Hopefully no one ever sues you. And then the second they sue you, you have to run and go claim the original warranty. It's not a very pleasant feeling. All right, let's do the second case. Yes, sir.
So, beginning class, you get 3 types of warranty: the general warranty, the pump warranty. That's the covenant of general warranty. Those are the same thing. So, when I get my general warranty from my title company,
It's going to have a covenant season in it.
yeah, they're going to have that season in it, but what they're really referring to, the basic starts of the future covenant, is that general warranty. That's sort of.
Yeah, they're called different things though. That way, I don't want you to husband the terms. It's called quiet enjoyment. It's called general warranty. They're different names, so don't get hung up on what they're called, but whether they're future or present. That's what I want you to remember. Okay, let's do the second case, Dagny. What happened in Frimberger? I'm sorry, louder, please. No, give me the facts. What are the facts here? Okay. Good. By the way, what a wetland is? A swamp, right? We used to call them swamps, not to call wetlands. They can sound more elegant, but they're swamps. All right, so go on. What happened to the swamp?
They constructed violation.
Okay, good. So we have an environmental case. We don't do too many of these, but there's an environmental issue, right? You are not allowed to fill a wetland, right? What's that mean? Pouring concrete into a swamp so you can build on top of it. That is a no-no under the law. So what happened? The brother filled the land with cement. Okay, he didn't tell anyone about it. The fact is, at that point, that land was in violation of the law. Okay, the defendant then conveyed it by a general warranty deed to Frimberger. Okay, Dagny. We did a case similar to this like a week ago with a contract of sale. Remember the case? It was called, Loeber, right? Where the house was 1 story, it should have been 2 stories. And the house was too close to the sidewalk. In violation of the different zoning ordinances, right? Did the violation of the zoning ordinances make the title unmarketable? Yes, you're right. Remember this case we did like about a week ago, right? The house was, 1 story instead of 2. It was too close. It violated all these zoning laws and stuff. That violated the contract of sale because the title was unmarketable. This is very different. We are not here talking about the contract. We are talking about the deed. And under the deed, our concern is not marketability of title. Our concern is whether the warranties are violated. Okay. So, Yolanda, let me ask you this question. Is there any problem with the covenant of season if your land has some wetlands that are filled with cement? Cement pond, as hillbillies would say, right? Is there any problem with the covenant of season? I'm sorry, say it again? Yeah. Why is there no problem with the covenant of season if there's some cement in your land where there shouldn't be? Right. You own the full land, right? The person who conveyed it to you actually conveyed what they said they were going to convey. There's no dispute about it, right? Yolanda, what is the problem, of course, of having the swamp filled with cement? What's the problem?
The violation, I guess, pretty much what happened.
Well, that's true, right? And with environmental laws, once you have that swamp, you can't do anything on it. But Yolanda, when does having the concrete-filled swamp become problematic? Well, let me ask this question. So, Eduardo. Chris?
Yes.
Chris, let me ask this question. In this case, did the Connecticut Environmental Agency do anything yet? What actually happened? What has the Connecticut Environmental Department actually done so far?
At that point, they hadn't done anything. It was later when they introduced changes to the land that he asked like survey.
Yeah, and then what did the letter say that was sent to the homeowner?
But he had do like an application, I guess, for why he needed it.
Okay. So has anyone ever dealt with an environmental agency? Okay, so Chris, let me ask you. You haven't dealt with this, but try and use your common sense, right? If it's against the law to have a swamp filled with cement, and a government agency sends you a letter saying, "Give us a reason why you should have this," what do you think the response is going to be? What do you think the government's going to respond after you submit the application? Yeah, how do you think they're going to respond? Based on your experience with government, your limited time on Earth.
Can't do that.
Too bad, right? Yeah. Anyone ever ask for an excuse or permission from government to do something outside the law? Do they usually give exceptions, Chris? No, of course not, right? So the homeowner here is not an idiot, right? They know what's up. They know the second they apply for this permit, they're going to get rejected. And they're going to get a massive fine, and they're going to be required to remove the cement wall inside the swamp, right? So, Alexander, what do they do instead? Instead of trying to request a permit from the state, what do they do instead?
They sue under the covenant free of encumbrances.
Yes, right. So instead of trying to actually seek permission from the government to have the cement inside their swamp, they say, uh-oh, we're getting the hell out of here. We're going to sue under the general warranty deed that we got. Okay? We're going to sue under the general warranty deed that we got. Alexander, what's the problem, though, with such a lawsuit?
They weren't sued first.
By whom?
By the government.
Exactly. Alexander, was the covenant against encumbrances actually violated?
Yes, because there was a problem with the land when they got it, but since they didn't sue, the government didn't sue first, they can't.
Keep going back to the sentence. I think I forgot to ask a minute ago. Were they fined or sanctioned by the government? Will they be sanctioned by the government?
Probably.
Almost certainly. But until that covenant's breached, until they're actually sued by the government, until the government says, by the way, here's a bill, go fix it, and otherwise you'll go to jail, the covenant has been breached. So what did the court hold?
What, like damages wise?
What did the court hold? Could they sue on the future covenant yet?
Oh, no, because
It was premature, right? The court held that there's a latent violation of an ordinance. You cannot sue under a future covenant if the violation's latent. Same as the previous case. You have to wait until the government tries to shut you down. And then and only then can you go back and sue on the future warranty. I want to understand this, right? It's the exact same principle as the first case. Until a future warranty is actually violated, because someone sues you or fines you or something, you cannot sue on it. Yes, ma'am.
What happens to this? Do they turn off their right to sue? Or
What happens if what?
Like with this in general, like do they just lose their right to sue for that, or can like 10 years later, when if they do get sued by the government, can they then
Whoa. Uh-oh, that's not good. So your answer is what happens if they get sued in 10 years, right? Is that your answer? When does the statute of limitations start running on a future covenant? So what if you're disturbed in 10 years? When does the statute of limitations start running? When you're disturbed, right?
So it doesn't matter if they lost.
It makes no difference, right? It makes no difference that they lost. It's a weird feeling though, right? Because you basically have to sit around waiting for the government to shut you down. Waiting for that day when the government finally sends you a sanction letter saying you're going to be prosecuted, right? But until that happens, you cannot sue. Yeah, I mean, isn't that the rub, isn't it, right? You basically have to wait to get shut down, and only then can you go and sue on the covenant. It's the same deal as the case we just did a few minutes ago, right? Until there's actually an action against you, until someone tries to sue you over the mineral rights, you cannot bring the covenant. Okay? Let's do it. Yes. IT sport while teaching. Good. Yes.
So anecdotal use, the covenant of free from encumbrances, is that I thought it was a present at first, but now we're talking about it as a future.
They're called different things, which is why I don't want you to get too hung up on them, right? In this case, you're dealing with a future covenant that someone won't bother you, right? This is exactly why. Don't get hung up on the terms. Focus on whether it's a future or a present. And the way you know this is based on the language. If it's a present tense language, it's present. If he's in will and forever, and the verb is future. Any questions on this? Yes, sir.
I have a question along that line. If it was against encumbrances and encumbrances free from encumbrances, we have listed as present, couldn't they have sued in years without being sued first?
That's generally not a present covenant, though. Right? The issue here isn't that at the time you sold it, someone else had the right. The issue is, will someone try and sue you over it, right? So what you're describing is generally only framed as a future covenant. Understand?
Yeah.
Say your question again. I think maybe it.
So the covenant of free from encumbrances is not present.
Generally not. No. Generally, the only covenants you can sue on at the time of the sale is at Sizen. Yeah. Look at the three we have listed before. I'll show it to you, right? Covenant of Sizen, right? And free from encumbrances, right? But well, so you're saying here's a very technical answer. Merely having the cement in your swamp is not an encumbrance. What becomes an encumbrance is an enforcement action against you. So I think the exact same result would happen in either case. Okay, I think I'm sorry, I didn't understand you the first time, but the question was, why couldn't you sue under number 3, the free from encumbrances? Merely having the cement in your swamp is not an encumbrance. Only when the government prosecutes you for it, at that point becomes an encumbrance. I think that's your question. Yes, sir.
In the event that you know there is a problem, can you create a straw buyer and then seek indemnity from the person that sold it to you?
That's what we call fraudulent conveyance, right? So if you try to use
It's not fraudulent. You just have a straw buyer.
if you're using a transaction to get around a debt, that's what's called fraudulent conveyance. You can't do that. Don't do it. This guy, no, you won't. Other questions? All right, so the last case discusses a topic which doesn't really fit in, but it's called delivery. Okay. So are you guys take what, trust and estates next year, I think, or next semester? I don't even care. You don't care, right? Whatever. There are two types of gifts when you want to give someone property, right? There's what's called inter vivos and testamentary. Testamentary. Inter vivos, as the name suggests for those who speak Spanish, means during life, right? During life. If I, give you this cup during my life, I hand it to you now. It's an inter vivos gift. It's fine. There's no problem. Okay? Easy. A testamentary gift means afterlife, right? In other words, I say, when I die, I want to give you my car. I want to give you my house. Okay? But as I'm sure many of you are aware, when you give a testamentary gift that takes place after death, you have to follow the law of wills, right? Something called the statute of wills. What does that mean? Very easy explanation. If I give this to you, right? And then the next day I come back and say, wait a minute, I never gave this to you. You stole it from me. Okay? I'm still alive and I can sue to reclaim my property. With death, that doesn't work. If I say, when I die, I want to give you my car, and then I'm dead, there's no way for me to sue saying, wait a minute, I never said that. Right? Maybe he's lying. Maybe he made up this entire promise about the car. So with testamentary gifts, they have to be in writing and signed by two people. It has to be writing with two witnesses. The reason why is to protect the dead person. That's why if I say I'm giving you this car, and oh, by the way, I'm going to write it and have two witnesses sign it, there's going to be no doubt that I actually intended to give this car. Okay? I don't need you to know wills and trusts and estate law for this class. I don't really care. The only thing you have to know is if this is a testamentary gift, it must be wills, and that means it has to be in writing with two witnesses. If it's an inter vivos gift, that's fine. I give you this car today. You keep it. I don't need any writing. Statute of frauds doesn't apply to these sorts of gifts because there's no payment involved. If it involves payment, there's certainly going to be a writing, and therefore we don't have to worry about this. Where's my cup? I think I gave it away. Oh, there it is. Anyway, so everyone with me so far? Where this gets funky is where people try and play and bend the rules. Okay? Signing a will is expensive and takes time, right? You need to get a lawyer. You need to get the witnesses. Also, if you're old and you want to screw your children over, you may not want to have a will, okay? It's very often the case that parent says, I don't want my estate to go through this entire process. Let me just find a way to give it to my kids now. So what if a parent says, I'm going to give you my house after I die. I'm going to keep living in it now, but I'll give it to you after I die. Ryan, what kind of gift is that? There's only two choices. No, I'm saying I will give you this gift, this house after I die.
Oh, okay, yes. You're not making your it doesn't come until after your death, so
okay, good. So would that have to be written with two witnesses?
according to that, yes.
Okay. What if I say, Ryan, I will give you this house now, but I'm still going to live in it?
That should be your viewers.
Ah. But what if I can take it back during life? I say, I'm giving you this house, but I'm still living there. I didn't give you any paperwork for it. And maybe tomorrow I can kick you out. What kind of gift is that?
It's still viewers, right? You're giving it during life, regardless of.
Okay. The tricky part, and this is what's in the last case, the Rosengrant case, is like this. If I'm going to give a gift during life, it must be irrevocable. I can't take it back. So what happened in this case, right? Grandma and grandpa were living in a house. They got old, and they wanted to leave it to their favorite nephew, right? They wanted to leave it to their favorite nephew. Josh, why didn't they just give it straight up to the nephew saying, here's a title to my house, inter vivos, take it now? Why didn't they do that?
Wasn't it because they knew they were sick, and so that it was going to be, after they died, they were going to give it to them?
But why did they give it to them during life? Why didn't they just hand them the title? Why do you think? Really easy answer.
So they can keep living there?
Yes. Once you hand someone the title to your house, they can throw your butts out. Right? As nice as a nephew is, once you give someone the title to your house, you don't own anymore, they can throw you out. So it's very rare that someone will give up their house during life. So they said like this, right? I'm going to give you the deed now. We're going to hold it in a bank. And when we die, we want you to pick up the deed. Right? Jack, was the delivery, though, immediate?
No.
What was the problem with that case?
Well, I think the banker dies too.
That doesn't matter, yeah.
I didn't want to get there. Yes.
My bad. I
That's
don't know what it is.
I mean, he doesn't get the deed. They keep it in the
Okay.
in the vault.
And there's a key fact, right? On the envelope of the deed, what did it say?
Oh, it had their names. It said
Both their
Harold-
names, right?
Harold Or
So at any point during the life of Grandpa, could he have taken the deed back?
yes.
This is the key fact, my friends, right? When you give a gift, it must be irrevocable, right? You say, I'm giving this to you now, I'm not going to take it back. But in this case, what happened was Grandpa put the deed in the bank but said, I may take this back. If you stop taking care of me, I can yank it back. And that becomes a gift that is not inter vivos. Because if it's inter vivos gift, it's permanent. But that was effectively a testamentary gift. Because once the first party in the envelope is dead, the layperson can take it to second party. But that means it only comes into effect after death. And that's required the signature by 2 witnesses, which this was not signed. So in order to avoid the probate process and avoid the will process, Grandpa tried to do something, a little fast and loose with this entire put in my hand, put in your hand. None of it mattered because the point was it wasn't permanent. Grandpa kept living there. He was paying taxes on it. He was, for all intents and purposes, the owner, right? And if you're still the owner, it cannot be an inter vivos gift because you have not actually given it away. And the concurring opinion basically said that conversation with the banker was awfully convenient. I don't buy it, right? The concurring opinion said there's no way this actually happened. In other words, Junior was maybe making it up. We don't know. Okay. Questions on the last case? Right? I mean, the idea here with delivery is that you have to have a present donative intent to give it now. If the intent is you give it at some point in the future, that is a testamentary gift, which must satisfy the statute of wills. Any questions? No? Have a wonderful day. I will see you all on Monday. Wednesday, holiday. Very good. I'll see you on Wednesday.